The California Regulatory Explainer on Public Hearings under California's APA, or the Administrative Procedure Act. Now, as part of California's APA statutes, a rulemaking body of the executive branch of state government must conduct a public hearing on a proposed regulation if requested to do so by a member of the public. Pursuant to Government Code Section 11346.8, if a public hearing is held, then both oral and written statements, arguments, or contentions must be permitted. However, the agency may impose reasonable time limitations on oral presentations. This section of the California Government Code also specifies that a public hearing must be held if no later than 15 days prior to the close of the written comment period, any interested person or his or her duly authorized representative submits in writing to that state agency or department a formal request to hold a public hearing. And if such a request is made by a member of the public, then the state agency must provide notice of the time, date, and place of the hearing by mailing that notice to every person who's filed a request for notice with the state agency. California law also requires the state agency to consider all relevant matter presented to it before adopting, amending, or repealing any regulation. The state agency has the authority at any hearing to administer oaths or affirmations by those who appear before it. An agency may continue or postpone a hearing to a time and place as it determines. However, if a hearing is continued or it's postponed, then the state agency is required to provide that notice to the public as to when the hearing will be resumed or rescheduled. Also, under this section of the Government Code, if a comment made at a public hearing raises a new issue concerning a proposed regulation, and a member of the public requests additional time to respond to this new issue before the state agency is taking final action, then it's the intent of the legislature that rulemaking agencies consider granting the request for additional time if, under the circumstances, granting the request is practical and it does not unduly delay action on the proposed regulation. Now, how have California courts viewed the public hearing requirements under the state's APA and the Government Code? A hearing on a proposed regulation is on the merits and meaningful as required by the APA only if the interested public has timely received all available information that is relevant to the proposed regulation, that it's accurate and as complete as reasonably possible, regardless of whether large numbers of interested people were provided an opportunity to be heard at the hearing. This was said by the California Court of Appeal in the 2013 decision of Sims versus Department of Corrections and Rehabilitation. In another Court of Appeal decision in 1982 in Stauffer Chemical Company versus the California State Air Resources Board, the appellate court said that although the right to a hearing is a quasi-legislative matter, it's not constitutionally compelled. Both the mandate of the APA and the principles of fairness require a public hearing before a state agency. The purpose of the hearing, in part, is to provide an evidentiary record permitting meaningful judicial review. The hearing not be trial-like in nature, nor is there any ineluctable right to present rebuttal evidence at these hearings, or any requirements that the agency prepare findings in support of its quasi-legislative decision. And finally, where statutes prescribe hearing provisions for various individual agency proceedings, those provisions prevail over the more general provisions of the APA. This was the Court of Appeal in 2015 in AIDS Healthcare Foundation versus the State Department of Healthcare Services.